Hi guys, and welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today, we continue with our series on partnerships and we'll be talking about the management of the partnership as well as the distribution of profits and losses. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Hitting the like button on this video and any of my other videos will also be highly appreciated. Okay? Now, if you remember from my previous video, I said that a partner has certain rights coming from the contract of partnership. This includes the interest in the partnership as well as the right to participate in management. Okay? When we talk about the interest in the partnership, we are talking about the distribution of profits and losses. Okay? But first, let's begin with a discussion on the right to participate in management. Now, this right to participate in management springs from the proposition that every partner is an agent of the partnership, okay, for the purpose of partnership business. Therefore, the act of every partner, including the execution of any instrument in the partnership name for carrying on the partnership business in the usual way, it binds the partnership. Okay? Therefore, when it comes to management, these are the following rules, no? First, when the manner of managing the partnership has not been agreed upon, okay, there is no agreement, whether in the contract of partnership or in the articles, okay, if the manner of management has not been agreed upon, then all of the partners shall be considered as agents of the partnership, and therefore what any of them may do alone shall bind the partnership, okay, because they are agents. Now, if there is an agreement on management, then it depends. I'll be giving you the rules now. First rule, when only one partner is appointed as a managing partner, then that managing partner may execute all acts of administration despite the opposition of his partners, except of course if that managing partner acts in bad faith. Okay? Now, take note, there are two sub-scenarios under this scenario. If the managing partner was appointed manager in the articles, no, meaning in the contract of partnership, then his power is irrevocable without just or lawful cause. He cannot be removed unless there is just or lawful cause. Now, to remove that managing partner for just cause, then the vote of the partners representing the controlling interest is necessary. They still have to vote, okay? If there are there are more than one partners who have the controlling interest. Of course, if the partner who has the controlling interest is only one, then his vote will be the deciding vote, okay? Now, what if there is no just cause, but the partners want to remove him? Can he be removed? Okay? It is submitted that yes, he can be removed, but the vote must be unanimous. Why can he be removed? Because it is submitted that this represents a change in the will of the parties. So all of them have to give their consent to modifying the contract of partnership to remove him as a managing partner. Okay? Now, second sub-scenario, no? What if the power to manage, no, or the appointment of that partner as a managing partner was granted after the creation of the partnership, meaning it's not written in the contract of partnership or in the articles, okay? Then being the managing partner, he may be removed, no, or the power granted to him may be revoked by the partners having controlling interest or such composition as may be prescribed, no, in the articles or in the bylaws at any time, okay, for any cause, okay? You just follow the bylaws, the articles, or upon agreement by the controlling the parties having controlling interest, okay? Why? Because take note, his appointment as managing partner took place after the creation of the partnership. Therefore, it is a mere delegation of power. You are given the power to manage after we have created the partnership. Okay? And it is not a condition for the contract of partnership, unlike in the previous sub-scenario. Okay? So there is no more need to modify the contract of partnership. Okay? Now, as to compensation, generally, the managing partner is not entitled to compensation. However, of course, the parties may expressly grant it to him in writing, or it may be implied from circumstances, such as when he has gone above and beyond his duties, or etc. Okay? Now, the second rule, in case there is agreement, is what if two or more persons or partners are entrusted with management and without specification of the respective duties, or without stipulation that one of them shall not act without the consent of all the others, no? This situation, no, you take note, the partners, of course, can agree that if they appoint two partners, one of them is in charge of only these acts and one of them is in charge of only these acts, then walang problema, no? It's just managing partner of these acts and managing for that. Okay? But this situation contemplates a scenario where it was not said what are the responsibilities of each. Okay? Or there is no stipulation here that one of them shall not act without consent of all of the others. Okay? So that's the situation here. If that's the situation, then each one of those managing partners may separately execute all acts of administration. But if any of them, of those managing partners, should oppose the acts of the others, then how do we resolve that conflict? It will be resolved by majority decision. Okay, they will have to vote. Now, what if the decision results in a tie? Okay, then if it's a tie, it will be decided by the partners owning the controlling interest. And what if in that case there is still a deadlock, no, in the tie? Okay, you still cannot resolve it. Then those who vote against the contract will prevail, as it is considered entered into without authority. Okay? Now, third rule, okay? If it is stipulated that none of the managing partners shall act without the consent of the others, meaning in order to perform an act, you need to get the consent of everybody, then every one of the partners must consent for the acts to be valid. And further, they cannot allege that one of them cannot vote because he is absent or disabled. The only time they can say, no, let's proceed with this because this partner is absent or disabled, the only time they can do that is if there is immediate danger of a grave or irreparable injury to the partnership. Okay? Now, this requirement of previous approval by everyone applies only to the execution of formal contracts. Okay? It does not apply to routine transactions, no, which you can do on a day-to-day basis without the consent of others. Finally, please just take note that when it comes to immovable property, we also have a rule. None of the parties may, without the consent of the others, make any important alteration, no? Important alteration meaning useful expenses, not necessary expenses, because necessary expenses can still be done. None of the partners, without the consent of the others, may make any important alteration in the immovable property of the partnership, even if it may be useful to the partnership. Okay? Because the immovable property goes into the very heart of the partnership relation, no? And the rights of everyone will be affected. Okay? Now, if the refusal of consent by one or more of the other partners is manifestly prejudicial to the interest of the partnership, then the remedy is they simply go to the court and ask for the court to resolve the issue. Okay? Now, those rules that I just mentioned, okay, they are not imposed upon, and they do not affect a third person. Okay? They do not apply to a third person. Those are rules that affect the relation among the partners. Okay? It doesn't affect a third person who does not need to verify who is the managing partner or whether the consent of other partners have been obtained, as the case may be. No? A third person who transacts with one of the partners does not have to ask, oh, are you the managing partner? Oh, did you get consent of everyone? He does not have to do that. He has the right to presume that the partner with whom he contracts has, in the ordinary course of business, he has the consent of his co-partners. In other words, okay, these rules govern only the relationship among the partners themselves, and a breach of any of these rules results only in a cause of action against the partner who is at fault. Okay? These rules will not invalidate transactions or contracts entered into with third persons in good faith. Okay? Now let's give some examples of how to apply the rules. So let's say Goku, Gohan, Vegeta, and Trunks, these 4 people, organized a general partnership with Goku and Vegeta as industrial partners. Okay? Now, Gohan contributes 30,000 pesos and Trunks contributes 10,000 pesos. Okay? Goku and Vegeta were also both appointed managing partners without specification of their respective duties. So now, they both appointed Frieza as an accountant. Okay? 1 year later, Vegeta wanted to dismiss Frieza, but Goku opposed. He said, no, I don't want to dismiss Frieza. Okay, so how do you resolve that conflict? Okay? Now, as I mentioned earlier, the rule is decided by the majority of the managing partners. In this case, the managing partners are Goku and Vegeta. But there are only 2. So there's no majority there. They're opposing each other. Okay? So there is a tie. So the rule now says that it will be decided by the vote of the partner who has the controlling interest, which is Gohan. Why? Because he has the biggest share, 30,000. Okay? So his vote will now govern as to whether or not Frieza will stay. Okay? Now, in that same example, okay, the partnership of Goku, Gohan, Vegeta, and Trunks, no? No one is appointed as managing partner, okay? So, Frieza was also hired as an accountant, then Vegeta wants to remove him, and Goku opposes, okay? Again, no one is appointed this time as managing partner. How will the conflict be resolved? Then the decision of the majority will prevail. If it's 3 versus 1, then of course the majority will prevail. In case of a tie, again, controlling interest, Gohan will decide. Okay? Now we can move on to the next topic. The next topic I want to talk about is the right of the partners to share in the profits as well as their obligation to share in the losses. Okay? The rules when it comes to distribution of profits would first depend upon the existence of an agreement. If there is an agreement, then the profits will be distributed according to the agreement, no, of the parties, even without regard to their respective contributions. The determination of the share may even be entrusted to a third person. Okay? However, this is subject to the rule, no, to the prohibition against pactum leonina. In other words, again, pactum leonina, lion's share. Okay? In other words, a stipulation which excludes one or more partners from any share in the profits or losses is void, no? So let's say these 4 are partners. They make a stipulation that Gohan, the capitalist partner, is excluded from sharing in the losses. That's not allowed, okay? And take note, only the stipulation is void. The existence of such stipulation will simply be considered as not written. It will not affect the existence of the partnership. The partnership will still go on, okay? Now, that's the rule in case there is an agreement, no? You just follow the agreement. If the agreement says 30% for Goku, 10 for Trunks, then 30 each for Vegeta and Gohan, then you follow that, even if their contribution is different, okay? But what if there is no agreement, no? These are the rules. First, the industrial partner will receive a share as may be just and equitable. Okay? Will be just and equitable, of course, in comparison to in relation to the work or output he has given. Okay? And this share of the industrial partner must be paid before the capitalist partners are paid. Okay? The industrial partner must first receive his share before the capitalist partners can divide the profits. Now, what if the industrial partner has also contributed capital? Then he shall also, in addition, he shall also receive a share in the profits in proportion to his capital. So he can stand to receive the biggest share possibly, Okay? Now, when it comes to the capitalist partner, his share, of course, shall be in proportion to his capital contribution. Okay? If he contributed 20%, then he gets 20% of the profits. Okay? So that's it for distribution of the profits. What about sharing of the losses? Of course, if there is an agreement, follow the agreement. Okay? If you answer for 10% of the loss, then that's what you answer for. But if there is no agreement, okay, as to the sharing of losses, then you follow, if there is an agreement as to the profits, you follow that. Okay? If there's no agreement as to the losses, and there is an agreement as to sharing on the profits, you follow the sharing of the profits. If it says that Goku will receive 20% profit, but it's quiet about the losses, then he shares in 20% of the losses. Okay? Now, if there's nothing absolutely, no sharing, no agreement as to losses, no agreement as to profits, then what will be the distribution of the losses? Then losses will be distributed in proportion to their capital contribution. Okay? If Goku gave 20%, then he shares in the losses at 20%. Finally, where a designation of the share of profits or losses is made by a third person. No? Kasi if you remember, I just mentioned that the determination of the partner's share or in profits or losses can be given to a third person. No? Frieza can determine what their sharing will be. When that third person makes a determination, that decision of the third person is binding. The only time it can be challenged or impugned is if the decision of the third person is manifestly inequitable. Okay, that's the only time it can be challenged. But a partner cannot complain of or cannot challenge the decision of the third person if he has begun executing it or if he fails to impugn it within 3 months from gaining knowledge of the decision of the third person. Okay? Now, take note again, I just want to emphasize that generally a stipulation excluding a partner from any share in the profits or losses is void. And only the stipulation is void, the partnership subsists. And the profits or losses shall be apportioned as if there was no stipulation. That's Pactum Leonina, ha? Just take note that even though that is the rule, remember there is also another rule when it comes to an industrial partner. The industrial partner shall not be liable for losses. And take note, liability is different from loss. Okay? Liability refers to your responsibility toward a third person, a creditor. Okay? You have to pay that creditor. Losses refers to the responsibility among the partners. Okay? Liability to third person, losses among them. Okay? Why do I mention this? Okay? Because let's say Vegeta is the industrial partner. He is not, he's exempted from sharing in the losses. Okay? If the partnership suffers a loss, he does not have to answer for the loss. But, can Frieza hold him liable? Yes. Okay? Liability is different. And Vegeta must pay. Okay? Now, what is the remedy of Vegeta? He can go after his co-partners for payment of what he may have paid to Frieza because Vegeta is not supposed to share in the losses. Okay? Now, let's just give some examples. Okay? So, let's say Goku, Gohan, and Vegeta form a general partnership and Goku gives 20,000, Gohan gives 40,000, and Vegeta 60,000, 20, 40, 60. Okay? And now there is no agreement on the division of profits or apportionment of losses. Okay? So after a few years, the assets of their partnership dwindled to 30,000 only. Okay? Nalugi. Okay? And all of them agreed to stop the business. However, the partnership has a debt to Frieza. Frieza is the creditor. For how much? 120,000. It's bigger than 30K. So how can Frieza get paid? Now, the debt to Frieza is a partnership obligation. So, the rule is, all of the partners shall be liable pro rata or proportionately with all their properties after all the partnership assets have been exhausted. So, in other words, Frieza can get the remaining 30,000 of the partnership and compel Goku, Gohan, and Vegeta to pay the balance of 90,000 in proportion of their contributions. Remember, 20, 40, 60, right? So, the ratio is 2:4:6 or 1:2:3, okay? So, for how much is Goku liable for? Goku is liable for 1/6 of 90,000 or 15,000, okay? Gohan is liable for 2/6, okay, or 1/3, no, of 90,000, which is 30,000. And Vegeta is liable for 3/6 or 1/2 of 90,000, which is 45,000 from their own personal properties. Okay? Now, another example, in the same, Goku, Gohan, and Vegeta form a partnership. Goku 40%, Gohan 40%, Vegeta 20%. Okay? Goku and Gohan supply the entire capital. Okay? So they're capitalist partners. And Vegeta is the managing partner. Okay? He will be manager for 5 years without compensation. So what is he? He is also an industrial partner because he did not give anything. Okay? Take note, even if I said earlier, Vegeta 20%, he did not give anything. So what is he? He is an industrial partner. Okay? So let's say their partnership now becomes bankrupt. Okay? Can Vegeta be removed as manager? Okay? First, no? Goku or Gohan alone cannot remove him. It has to be the vote of the partners representing controlling interest to revoke Vegeta's power. And can Vegeta be held personally liable for the debts of the partnership which are not satisfied with the assets of the partnership? Okay, like in the example earlier, where they owe 120,000 to Frieza, but the partnership only has 30,000. Can Vegeta as industrial partner be held liable? Yes, okay, he can be held liable by Frieza. Okay? Take note, I'll explain it first, no? The liability first of Vegeta is joint, okay? Because all partners are jointly liable. Okay, and while it is true that the law prohibits pactum leonina or a stipulation excluding Vegeta from losses, no? That will not apply to him because he is an industrial partner. He will not share in the losses, okay? The 20% stipulation on Vegeta's share only applies to the profits he may receive. Because under the law, an industrial partner will not be liable for losses. Okay, but again, remember I mentioned earlier, when we talk about losses, that goes into the relationship of the partners amongst themselves, which is different from liability to a third person. So again, Frieza can hold Vegeta liable, okay? Can hold Vegeta liable, and then Vegeta will just have to claim reimbursement from Goku or Gohan for what they may owe the partnership, okay? Because again, an industrial partner does not share in the losses, okay? So that's it for management of the partnership as well as the distribution of profits and losses. I hope you may have picked up a thing or two, and I hope to see you next time, guys. See you soon. Bye.